I feel like I have courage and can speak out is because David, he's like, why don't people just say how they feel? And why can't, what's hard about a conversation? He didn't understand what could be hard about a conversation. He just, if you have to say it, then say it. I'm like, oh my gosh. I know. I agree.
Hey guys. Welcome back to my channel, and we've got to discuss Ysabel Brown and her lawsuit that's occurring in Utah. And some of you are unsure as to why we'd report on court cases of reality TV individuals, because that's what we do on this channel, and we report on all things sister wives, whether legal or not legal, of the individuals on the show. I reported on a lawsuit in which Mr. Peyton Brown was sued by two ladies in Nevada, and here in this case it's not different. But in Ysabel Brown's case, this case is concerning an accident that occurred a couple years back. So there was some skepticism here with some of you in comments that this could not be on the up and up, and you weren't certain about how you felt about it and whether this individual suing them could have eyes out for money because they know that maybe Isabel's mom is on a reality show. But in any case, Isabel had a duty under the law to answer the lawsuit, and she's defending herself, and she's actually seeking a jury trial here. So, that's good. I suppose you know the one thing you can say is when you get sued, call an attorney and get assistance, right? And that's precisely what Isabel did. Now, if you remember, she's being sued in the state of Utah, and the woman suing her says that a couple years ago, they were driving on a segment of highway that's very busy. And Isabel, she claimed, was going too fast and too close to the person ahead of her. And as cars came to a halt during rush hour, Isabel wound up rear-ending or bumping the car in front of her. And then this one person says then that person bumped this other one and this other one bumped her. So it was a domino effect of an accident which can occur. And she was saying that she had experienced all sorts of damages and that she had lost the enjoyment of life. And it was, some of you were like really sympathizing, thinking that this was all bull because it occurred a couple years back. And there were others of you who were like, no, Isabel needs to be held responsible if this actually did happen. So, she retained a lawyer, and her lawyers are claiming that her first defense is that plaintiff's complaint does not state a claim upon which can be granted. So, she is not filing a motion to dismiss. Her second defense is responding to specific allegations of plaintiff's complaint. Defendant admits, denies, and alleges as follows. So, she does acknowledge some of this, and then other aspects of this she doesn't. She denies it, or she can't say if it's true or not. Thus, Isabel confesses that she did possess a driver's license at that time. She had taken driver's education. She knew the rules of safety, and she was driving an automobile on the I-15, and the other plaintiff was driving on the same route at the same moment. But she denies these details. So she testifies that 11 and 13 behind the plaintiff's car was a car being driven by Mthus Vera Janadu. Right behind them was this other person, Jawat Marai. And the defendant was driving an Honda HR-V right behind Mr. Mariah's car. And Isabel denies that portion. So I don't know what she denies. She just does not know if those individuals were not involved. I do not know. And then she wouldn't say whose car or who was driving what type of car. So she wasn't able to answer that portion. So it appears she can't assert that she was driving behind this individual in this complaint, but she does acknowledge she does. She asserts she acknowledges that she rear-ended the car in front of her that caused the crash. And then she says that so in the suit that was brought against her, the woman said all of the other vehicles came to a stop but that Isabel did not. And she's the one who caused the accident, and she couldn't answer for certain whether that was a fact or not. She does say that she caused the accident, however. And she also says that she doesn't have enough information to confirm or deny parts of this, including that she failed to reduce her speed or maintain control of her vehicle. The force of the impact caused a chain reaction collision. The collision was caused by her negligence. And essentially what she is stating is that she does not have adequate information or knowledge to hold a belief regarding the truth of the charges found in 18-2, and thus admits the same, and she denies all allegations set forth in plaintiff's complaint not hereto admitted or denied. She denies all other parts of complaint. Therefore, all the other things are that since she caused the crash, and that the plaintiff got injuries, and that it's her responsibility, and that she suffered more than 3,000 injuries, and she endured pain and suffering in both of body and mind and loss of enjoyment of life. And so, she's denying that she was responsible for any of that, which I suppose when you're being sued, denial is one of the best ways to avoid some, denying it is a good way to go. It would be tough in this case if there's not like a crash investigation, and I don't know if there was to figure out who's at fault. But she also adds that she asserts that evidence potentially found to show that any damage, injury, or loss suffered by plaintiff was roughly caused by omissions and acts of individuals for whose actions this defendant is not responsible, and that she requests that any other such party name be specified on the special verdict form for purposes of fault allocation. So, it sounds like the way they're going to handle it is that she may have rear-ended one fellow, but she didn't make the other fellow rear-end that fellow to rear-end that fellow to rear-end the woman ahead of her. And I don't know how it would even work if the other two cars had stopped if she hit one. If the power of that single one would then make all the rest of the other cars travel forward if they're all in a standstill. I don't actually understand how that is. So I'm not a crash expert or an expert. And Isabel states that the behavior of all parties to this suit has to be compared in order to ascertain the extent of fault if any of the parties, and damage or loss has to be apportioned accordingly. So she's going to claim that despite the fact that she rear-ended the car in front of her, the other two vehicles could also have liability here if they were in motion too. And since she doesn't know whose fault it was that they collided with the car 4 cars ahead of them, all she can tell them is what she did. And so she's essentially requesting the court, listen, if there are other individuals who are party to this, then I have to know. And if there's anyone else whose fault is here, we need to find out. And they should share the payment of damages if that's right. And secondly, her other defense is that facts may be found to show that she has failed to mitigate damages and injuries if any. So, if she wasn't belted, if she didn't have an airbag in her car, if there's something with her driving that led to it or contributed, like maybe she was driving too hard, she wasn't that woman paying attention and she braked hard, right? So, if she braked too fast and it didn't give anyone else a time to respond, maybe that's the direction they're going to go. She's also stating that defendant claims that evidence will be uncovered to show the plaintiff has been paid personal injury protection benefits as a consequence of the motor vehicle accident bringing about this suit, and the amount thereof should be subtracted from any award herein by plaintiff. So, if she did have car insurance and any of that car insurance paid for it, like if she got injured in the car and the woman who owned the car had an accident and then her insurance paid for her hospital bills or paid for her injuries on the basis of a claim that she made to her insurance, she is claiming that that would be deducted and she wouldn't have to pay for that. It is also interesting to note that she wouldn't visit Isabella's insurance company just because if she did have an insurance company, it would be a case between insurance companies and not between two individuals operating cars. And defendant reserves the right to interpose such other affirmative defenses available which may be found by discovery. She asks for judgment of no cause of action and for defendant's costs for such other relief as it's only inequitable. Thus, the state of Utah is among a number of states across the nation that has no fault when it comes to automobile insurance, wherein whoever is at fault or not, your own auto insurance will cater to your medical bill and lost wages up to a specific dollar value. And in the state of Utah, every single driver is required to cover a minimum of insurance of $3,000 in personal protection, which is personal injury protection. And personal injury protection in the state of Utah does not cover for pain and suffering, and it doesn't have big damages there. What it pays for is medical expenses, accident compensation, income loss, special damages for activities an injured individual cannot perform such as domestic work due to their car accident injury. If they pass away, it will cover funeral or burial, and to the heir of the person in case the car accident leads to a covered person's death. So, you can sue the other party if you have costs beyond what was paid by your own insurance. And as stated by Nalo.com, to go outside Utah's NoFault vehicle insurance claim framework and make a claim against the driver who caused your accident, your case must reach certain threshold standards. Therefore, for them to make a liability claim against the other motorist, the injured motorist must have, first, incurred a minimum of $3,000 in medical expenses due to the accident, and they must, also, have incurred severe injuries. And such types of injuries would fall under an injury threshold which include permanent disability, permanent impairment, permanent disfigurement, or dismemberment. And if your injuries fit into one of those, you're not confined to a no-fault claim through your own policy. Then you can sue the driver and you can make a third-party motor car insurance claim or a personal injury claim, and then you can recover losses for pain and suffering and non-economic damages. So I have no idea why she wouldn't just go directly to Isabel's car insurance company. I mean, maybe she did and got denied. I don't know. But because of how it is structured in the state of Utah when it comes to the insurance companies, you can't receive pain and suffering and other non-monetary damages that are a result of the accident. So, if you want more money, that's when you have to turn to outside of your insurance and turn to the third party. And it's strange though that it's like 2 years later and she's suing her now. And the one thing that I found strange about the lawsuit in general is that it was really vague. Similar to in general terms, when they file a lawsuit, it'll state the date of the accident, it'll provide the information, they'll have attached a crash report or they'll have attached a ticket, just to verify that the individual that they're suing is the one responsible for the accident. And they didn't mention anything like that. They literally didn't attach anything. And she also didn't mention what her injury was. Not that she's uninjured, it's just that she didn't specify what injury she had. She just mentioned that she incurred bodily injuries, that some of them could be permanent. So it seems that if they're not permanent and there's no permanent impairment or permanent disability, then she might not even have a claim. So that aspect of it might be a means through which she can excuse herself, since she clearly could have had injuries. But if they are not permanent, or if they may be permanent, you would sort of know if something's going to be permanent after a few years, though. I mean, if you got a concussion and you suffered a serious head injury, you would know within a couple years if that would be permanent. Or if you had a spinal injury or something seriously hurt you, you would know within a couple years if it's going to be permanent. But they say some of which might be permanent. So Isabel can then battle this by requesting a court to consider the totality of the circumstances. She can even have the court rule on whether or not this driver was violating any laws during the accident as well. So, then, on the Utah website I was reading, they say that this individual was speeding. If she was speeding and she was also in violation of the law when the accident happened, and then she braked while speeding, and then that would not leave sufficient time for other individuals behind her to brake at a safe rate, Isabel could be found not to be at fault. And if there are all these other vehicles involved, these 2 other vehicles, you think that you'd have to determine first of all what the speed of all the vehicles was, what the crash report reads, what the ticket reads, and none of which has been brought to the court. So, I don't know. It's a very general complaint. And therefore, I believe Isabel is within her rights here to defend herself. And under the laws of the state of Utah, the standard is really high in winning cases of this nature. And therefore, just because she claims Isabel is at fault does not necessarily mean that Isabel is at fault. And just because she claims she was harmed due to Isabel does not mean that she was harmed due to Isabel. The universe of automobile accidents is a science I will never know. But I do know that she would have had to go to Isabel's insurance company and not directly to Isabel. And there is no talk here of insurance, which I find strange because both drivers by law are required to carry insurance. And so the claims must be with the insurance companies. And she is not claiming that Isabel was not covered. So if Isabel covered, then she should be visiting Isabel's insurance organization, not Isabel herself. So Isabel can also say that, but she's going to retaliate. And I think just from the complaint itself, it seems that she has some latitude. I'm not a lawyer, but to me it does appear somewhat fishy because there is just such a paucity of information here about what precisely the injury was, what it resulted in, and what happened. And I always get the feeling that in a complaint, you ought to give as much information as you can. And I think that's also why Isabel's like, you didn't even state a claim because you didn't inform me of what your injury was. You didn't inform me of how much you paid at the hospital. You didn't give me a copy of the accident report. You know, you haven't really informed me how this is my fault because I don't even know what occurred to you. So, how do you state that someone's seriously hurt and it's your fault without informing the person these are what my injuries were? So, we'll just have to see how it all works out. So, I'm happy that she's got an attorney. I'm happy that she's got a good lawyer. And hopefully it all works out and it's resolved in court because these types of cases are a nightmare to work with. And if the individual suing her is suing her because they know that Isabel's on a reality show and it's for money and it's 2 years later, it just doesn't make sense. It just feels like strange timing, to be honest. But that's my opinion only. So, tell me what you think in the comments below. Don't forget to give this video a thumbs up. Don't forget to subscribe to my channel if you've not subscribed and press the bell so you never miss a video. Thank you so much for watching.